Hello everyone, I welcome you all to Manu Law Classes Current Affair Analysis. In this particular video, we will discuss September 23, The Hindu Delhi edition newspaper. So our first news is about Sport Minister. He will skip the Asiad inaugural as China bars entry of the Arunachal Pradesh players. So one Wushu player, he was not allowed to board the flight and two other were stopped at Hong Kong. So the players from Arunachal Pradesh, they were actually stopped by China, by Chinese force, and this was against the differential treatment of the citizen, which is based on domicile or ethnicity, which MEA or the Ministry of External Affairs has claimed. It is against the equality part of the sports, and here they are just working against this particular principle, and also this will definitely harm the all those players who are basically visiting the China for this particular game or the Asiad inaugural game. So all the three sports person, they had valid accreditation. Even after that, they were stopped from deboarding for going to China, and that is against the wishes of these sports person. So this is about this whole news. Moving further toward our next important article, that is coming in from a judgment of Delhi High Court. So it is not a crime if consenting married adults, they are living in live-in relationship with other people. So this is a judgment which has been passed out by High Court. Now moving further toward our next important article, that is coming in from the Canada section, and here Canada's soft approach could embolden Khalistani radicals as said by experts. So as we know that Khalistani extremists, they are there in Canada, and the Canada's soft approach, or we can say support, it actually empower their feelings. So here Canada is being seen as soft on Khalistani extremists amid the strained relationship with India. So they are also saying that this is a kind of pro-Khalistani radicals in Punjab and outside the country they have spurred. So their growth or this feeling of Khalistanis, it has grown because of the soft approach of Canada government and Canada authorities. So here the observers of the state politics, law and order, they are fearing that if Canada allows such anti-India activists in the name of freedom of expression, then definitely it can embolden the radical element which is dangerous for Punjab that share international border with the hostile nation Pakistan. So there can be a possibility, as suggested by these experts, that Pakistan can intervene into India's internal problem, and here as we know Punjab is sharing border with Pakistan, so definitely if such kind of feeling of Khalistani radicals it emboldens, so it can be a problematic scenario for India as Punjab is already sharing hostile border with Pakistan. So these two elements can combine and definitely they can harm the sovereignty and the integrity of India. So the Khalistani movement, which was marked by the turbulent phase of the militancy in the mid 1980s, they lost its popular support in the region of Punjab as security experts who are pointing out at some point of time that they should not grow this sentiment in Punjab, but in the countries which is actually supporting these sentiments, one of the name is Canada. So that can be a kind of an initiative which can definitely embolden these feelings, and it can keep this idea or this long dead movement alive. So this is what about the experts' view with regard to these important happenings which is occurring. So as we know, Hardeep Singh Nijjar, he was a pro-Khalistani leader and he was based in the Canada. He was a Punjabi-based radical outfit, Dal Khalsa and Sikh Youth of Punjab. He was already in hit list, we can say he was there in as a declared as terrorist by Indian government, and he was gunned down, and here Canada is actually blaming India for that, but there is no proof that India has done anything or not. Now Shiromani Akali Dal, it posted on X that what Simran Singh Maan, or the party MP of Sangrur he feared and raised in Indian Parliament, has finally been confirmed today by the Canadian Prime Minister Justin Trudeau. So here the NIA is actually investigating, and it has sent several requests to Canada for the extradition and the deportation of terrorist operatives and pro-Khalistani element who are actually acting as a key danger for India's sovereignty. And here they wanted that this alleged involvement in cases of terrorism and other related offences, but this request was pending for years, and now when the Hardeep Singh Nijjar he was killed, the Canada government is blaming Indian government. So this is something we can say that Canada is actually having a soft approach to embolden the Khalistani radicals. So the Khalistan movement has lost popular support in Punjab, but in some part it has still, where like Sikh diaspora is very much in Canada, in UK, in Australia and in USA. This sentiment is still there that they should have a separate nation of Khalistan for Sikhs, and this sentiment is actually rising in these countries of Canada, UK, Australia and USA, as these people have money power and they are using this money to create trouble or to create turbulence in India. So they are acting through the sleeper cells in Punjab, and they actually try to make parts, or we can say try to divide the country and affect the integrity of the nation. So this is about this whole important article, and further we have some events like drugs, money, weapons and explosive. They are actually being pushed into India from the Indo-Pak border with the use of drones, and their recipient are basically, there must be some recipient of these, and in the backdrop of this we can definitely say that these powerful people who are living outside India, they are actually enraging people inside the India or in the Punjab province to actually act against the sovereignty and integrity of India. Now, moving further toward our next important article, that is coming in from the editorial section, and here we will discuss our article about dispute resolution. So a clear message to industry on dispute resolution. So here first we need to understand that the meaning of this alternative dispute mechanism. It refers to a bouquet of mechanism that enables disputing party to resolve their differences amicably without the intervention of the courts. For example, if there are two parties who have actually filed the case, and even if they have not filed the case, so in that case they can actually negotiate before going to court, so that there can be less pendency in the case court, and also there can be a peaceful resolution of any dispute. So we will first try to understand the modes of the alternative dispute resolution. There are three modes. We will try to understand that, and then after that we will understand the mediation bill which has been passed. So modes of ADR or alternative dispute resolution. First mode is arbitration. So arbitration is a process in which parties dispute is presented to an arbitral tribunal and it renders a binding rule or binding ruling, which is called award in general. So whatever be the arbitral tribunal will be referring, it will be binding on both the parties. So it can only begin if the party has a valid arbitration agreement in place before the dispute arises. So after analyzing the parties' disagreement, the arbiter, the person who is actually doing the arbitration is called the arbiter, he can resolve the dispute. So there is a law, particular law called the Arbitration and Conciliation Act of 1996. It is there, it governs the process of arbitration in India. Next process through which ADR or alternative dispute resolution can occur is mediation. So mediation is a process. Mediation is a process in which third party who is actually impartial to both the sides of the conflict works with the parties to arrive at an agreeable resolution. For example, a person who is not influenced by the two parties, he is impartial in nature, he will come and he will try to resolve the dispute of both the parties, and it is a voluntary, informal and out of court settlement. Okay, it is voluntary, informal and out of court settlement, and its outcome is not always legally binding. The third process in which ADR happens is conciliation. So conciliation is a way of settling dispute where parties work with the conciliator and he reach an agreement. So here both the parties work with conciliator and they reach an agreement, and the conciliator job is to get the parties to agree to put their differences aside and come to mutually agreeable settlement on the terms. So this is the job of conciliator. So these are the three ways in which the alternative dispute resolution actually happens. Now going back to our news, which is talking about that why there is a need of mediation and alternative dispute resolution. So the main reason behind is that there is a lot of delay in the Indian court proceeding, and there is also an increasing cost of litigation. And because of these particular condition, the significance of alternative dispute resolution in India is very much important. So earlier there was only emphasis on arbitration and conciliation of the dispute under the Arbitration and Conciliation Act 1996. But now mediation is also an important point as after the passage of the Mediation Bill 2023. So it got the assent from the president and now it is an act, the Mediation Act of 2023. So here Indian legal framework, it already encouraged these kind of ADR procedures including the mediation. Now there is already an act, it can definitely bolster all these particular alternative dispute resolution mechanisms. So here there are elements of settlement which the parties may accept. The act take this encouragement a step forward. So irrespective of the prior mediation agreement, it will obligate each party to take steps to settle their dispute through the pre-litigation mediation before approaching an Indian court. So before going to court, parties can first talk within themselves and they can mediate. Then after that, they can definitely go to court, and even after going to court, there can be mediation which can happen. So to facilitate this particular process, pre-litigation process, the Act requires courts and relevant institutions to maintain a panels of mediators. It can be, we can say that an impartial person is actually listening, an impartial person is actually going for the settlement between these two parties. So it is also a fair process, as well as there will be less number of litigations after this particular bill, after this particular act and legalizing this particular mediation process. So there are a lot of benefits from this particular move. That is, the requirement is expected to reduce the filing of the frivolous claim before the Indian court. So here the number of cases will definitely lessen up because of the mediation process. Other than that, owing to the confidentiality of the mediation, it can also mitigate the risk of deterioration of the parties' relationship due to publicly fought dispute. For example, whenever we go to court, definitely every person will get to know that there is a court case or there is, we can say, publicly fighting among these two parties. But if we go for mediation, so it is more or less a closed door agreement, और यहाँ पे आपका closed door में आपका जो ट्रांसपेरेंसी है वो मेंटेन रहता है, लेकिन साथ में आपका कॉन्फिडेंशियलिटी भी मेंटेन रहती है. नो पर्सन विल गेट टू नो दैट यू पीपल आर मीडिएटिंग और देयर इज अ डिस्प्यूट अमंग you two. So this can be a bit of like having a trust in these two parties they can maintain because there is no publicly fighting. At the same time, the concern was raised about the feasibility of the mediation, which is conducted under the sword of obligation as opposed to a sincere desire to arrive at an amicable resolution. But in the latter scenario, they can empower a recalcitrant defendant to delay a genuine case. So this act actually safeguard against these concerns, and here the mediation, it will require mediation to ordinarily be conducted by an empaneled mediator who must always be neutral and have uncompromising expertise. So there is always a question of doubt that whether that person will actually favor someone else or someone else, some one party. So here there is a situation that these panels of mediator which is being appointed by the courts, they will definitely be a neutral person, and here they will have a lot of expertise in this field. So as we know, there will be an extension to the parties. They must also complete the mediation within 180 days from the party's first appearance. So there is a lot of timing. In this much of timing, definitely people can change their mind, and because this much of timing is being given, there can be a lot of dispute which can be resolved by mediation process. So this act will not remove the refuge of Indian court entirely. A party in exceptional circumstances seek urgent interim relief from the court before the commencement or during the continuation of the mediation. A party can go into the court as well, and this also provides like it will ensure the pre-litigation mediation is not weaponized. So it is basically creating a balanced framework which actually encourages party to focus more on the commercial dealing and less on the dispute. So they can mediate and they can just talk, and in case if they don't find the mediation suitable, they can definitely go to the court and fight their case. Now there are aspects of mediation and arbitration. So Act is effectively position mediation similar to commercial arbitration in India. Similarities is between their respect of supporting piece of legislation, which is obvious, and both the legislation impose a stringent timeline for the conduct of proceeding. So as we know, there is 180 days of timelines in which mediation have to occur. So this particular timeline ensure that everything is going as per the demand, and here the conduct of proceedings, the confidentiality, it obligate Indian court to refer to parties to mediation or arbitration, and they will be provided default mechanism for the appointment of mediator or arbitrator. So here this particular act can definitely help the people. There is also an establishment of Mediation Council of India, which mirrors the proposal in 2019 to establish the Arbitration Council of India. So on a similar ground, there will be a Mediation Council of India, which will be established from this particular act, and definitely it can help the Indian industry. In case of the commercial matter, they can go for the mediation instead of going for the litigation. So this is about this whole important article. Now moving further toward our next important article, that is coming in from the state section, and here we will discuss about the important news again coming in from the Canada. So there is visa suspension for Canadian who are enforced at Indian mission globally. So the suspension is not applicable to those Canadians who hold OCI card or valid Indian visa, but other than that, even physical visa for Indian visas from Canada citizens to Indian missions in third country will not be processed under this particular suspension of Indian visa for Canada. So this is a new upcoming which is there, which has been informed by Ministry of External Affairs, as there is definitely a security threat because of the Khalistani issue going on. Now we will move further toward our next important article that is coming in from the World Affairs. So as we know, there will be 78th session of the UNGA, and in that our External Affairs Minister S. Jaishankar, he is he has been attending this meeting. So here the foreign ministers of the Quad country, that is India, Australia, Japan and USA, they have also met and they discussed that how helping country respond to terror attacks. So this is about this whole outcome, or as this was there in the Quad ministers meeting, and also reaffirmed the commitment to a free and open Indo-Pacific, which is their actually main aim of this grouping, Quad grouping. And here the disputes are settled in accordance with the international law. So this is about this whole article. The Quad also backed UN effort to restart the Black Sea Grain Initiative, which we have already discussed quite since a long time. BSGI, or the Black Sea Grain Initiative, is a deal that procures the export of grain from Ukraine and Russia, and this agreement has expired in July, with countries calling for its reassumption or resumption. And here the G20, in the G20 it was also discussed, but now till now it has not been reopened. So this is about this whole article. On North Korea, the statement condemned Pyongyang destabilizing missile launches and the pursuit of the nuclear weapon which is thereon. And on Myanmar, the Quad supported the transition to an inclusive federal democracy and the ASEAN 5-point consensus, which was actually made for the agreement between the Myanmar Janta and the ASEAN group of countries. So these were the important outcoming of the Quad External Affairs Minister or Foreign Affairs Minister meet. Also, there was a 9-day visit to US, and External Affairs Minister S. Jaishankar, he arrived in New York and he started the 9-day visit to US to address the 78th UN General Assembly and also the bilateral and the plurilateral meetings which is going on in there. So this was about this whole article. Now there is an important article which is also there in news. So it is related to the heritage news. Panel calls for revising the rules of construction around the protected ASI monument. So this particular amendment will be there in this Act, Ancient Monument and Archaeological Sites and Remains Act 1958. We will try to discuss this article, the important provision of this article, as this is in news, and what was the amendment which was proposed. So talking about ancient monuments and archaeological sites and remains Act of 1958. This has various issues. It is regulating various matters or regarding the ancient monument. So it talks basically about the preservation of ancient and archaeological or historical monument, and also the archaeological sites and remains of the national importance which is more than 100 years old. Regulation of the archaeological excavation and protection of the sculpture, carving and other like objects is also covered under this Act. And there is also the ASI functions under the provision of this AMASR Act. ASI works according to it, and based on that, India has a total 3,695 centrally protected monuments or sites which is under the protection of ASI, and they are being protected under this particular Act. So, monuments which are covered under this Act, they are regularly inspected by the ASI officials and they assesses their present condition and the necessary conservation and preservation work which is needed to be taken up as per the requirement. In the year of 2010, there was few amendment which was made to this particular Act. So, here this particular amendment tried to strengthen the penal provision to prevent illegal encroachment or illegal construction near to these monuments which is happening on large scale. So there was a creation of prohibition of 100-meter area around every national monument where there can be no construction, whether it is of public nature or private nature. No construction is permitted. Then there is another area which is the regulated area, which is somewhere around 200 meter beyond the prohibited area. So total 300 meter area is regulated. So here the construction requires the permission of National Monument Authority. Okay. If we want to construct anything in 200-meter area of an ancient monument, so we require the permission of National Monument Authority, and it has a unique nature of each monument. The Act also proposed the heritage bylaw for each monument to be prepared by the expert body. Further amendment have been proposed which seeks to do away with a ban of construction within 100-meter area of the ASI protected monument and regulates the construction within 100 to 200 meters of the area of the monument. So here the problem is basically that there are many villages who are within the radius of 300 meter of these protected monuments. So this prohibition of 100-meter area and regulation of the 300-meter area, it is actually creating a lot of problem to these local communities, and they are actually, there is a difficulty to carry out any necessary repair work in their residential space, and this is creating a lot of problem to them. So they just want that this particular act should be amended as they are not in their favor. So central government has already said it was in the process of amending this act, and the committee at present is basically trying to find out some rules which can actually work for them, and the rules above apply identically to the iconic Ajanta and Ellora monument and the Kos Minars, which has unknown cemeteries and the tombs. So there is a list of 3,691 ASI protected monument which need to be rationalized and categorized. So just remember the number of the monument which has been recognized by ASI as protected. It is around 3,691, and remember about this act and the provision which is there in news. Now moving further toward our next important article that is coming in from the World Affairs section. Here Syria and China, it has announced a strategic partnership ahead of the Asian Games. So China and Syria has announced the formation of a strategic partnership as Chinese leader Xi Jinping kicked off a series of diplomatic meetings ahead of Asian Games, and here Syrian President Bashar Assad, he is in the southern Chinese city of Hangzhou, and he is hosting a 15-day sport competition. So this is about this all important article. I hope you liked this lecture. I hope you got to know a lot of things. Thank you everyone. Thank you for attending this lecture.